it's Mark, Spinnaker Property Management, back again to continue our series about the initiative 2023-01. And we're just going to pick right back up on section 4. And it reads, landlords must not charge unfair or excessive fees. 1. Landlords are prohibited from charging tenants unfair or excessive fees. As used in this section, unfair or excessive fees means any of the following. A. Any rental applications fees not complying with RCW 59.18.257. B. Any non-refundable fee charged at the beginning of the tenancy, including but not limited to a fee to hold a unit prior to the tenant's taking possession, except as specifically allowed in this section or in specifically allowed under state law. C. A pet damage deposit exceeding 25% of 1 month's rent, or where the landlord may retain any part of the pet deposit exceeding the actual cost of repairing the pet damage. C. Move-in fees that in total exceed the first month's rent. If a tenant pays a portion of the rent and the remainder is covered by a subsidy, first month's rent includes both the tenant's payment and subsidy. D. Any fee or charge for late payment of rent exceeding $10 per month or that are paid or charged after the end of the tenancy, except as required by state or federal law. 2. Any rental agreement shall be deemed void to the extent it requires payment of fees prohibited by this section. This section shall not apply to or limit decisions, orders, and rulings of courts of competent jurisdiction. Okay, maybe you are as confused as I am after reading this, because if we start over with A, that's already an RCW, so why does that have to be included? Oh, and let me go back to the beginning where unfair or excessive fees is very generic and is broad with no definition. So how do we follow that? That is an opinion, right? So that in itself is going to be very difficult for anybody to follow, let alone defend themselves when court. B. So this section, I believe, is referring to admin fees that housing providers charge to process the steps it takes from the application to the lease execution to the keys and the inspection with the occupant or the pending occupant, and also the holding fee that housing providers use, which could other languages are earnest money, that if the applicant who's approved executes the agreement and chooses not to take possession, then those monies are held to cover the vacancy for that home being held offline because of the commitment to the renter. So I believe that's what they're asking for, is so that the housing provider doesn't have financial coverage for the losses when the occupant may not take possession. C. A pet damage deposit. Okay, exceeding 25% of 1 month's rent. Well, I understand the concern because there is a lot of occupants out there. 70% of renters or more have pets, which is great. And when that fee is less than the average damage that the pet causes, that's in addition to the damage deposit that's held for what could be caused by the occupants, I really am concerned that that limits the coverage that we get and increases the exposure to losses. Also in C, there's also a section C. I believe that's supposed to be in an additional area, like it should have been a D and then there's another E area. The move-in fees to exceed the first month's rent. Well, if it's a little confusing here, but I don't know that the move-in fees that they're talking about here are admin or reservation fees. It doesn't say what it is specifically or what they're trying to overt. However, it's very confusing, which in turn has more questions on the validity of this initiative. Okay, D, the fees charged for late, right? So they want to maximize the late fee at $10 per month. Well, late fees are designed as a deterrent from paying the rent late. It encourages people to pay on time. So if we were to minimize that to $10, what incentive would it give somebody to pay the rent on time? Why not just eliminate it altogether instead of just $10? So I think it's excessive. It's a very far reach to punish the housing provider and give no incentive to the renter to pay on time. In addition, there's a number 2 inside D that basically says that if any portion of this that gets enacted is violated and found to be in violation from the housing provider, then the entire agreement is void, which seems very aggressive and burdensome to the housing provider, because this is not only is it complicated, it also has very significant penalties if the housing provider is confused, misses a portion, and then now has to defend themselves because of that misunderstanding of the laws. So the fact that they're asking that the void to the extent it requires. And then at the very end, the last sentence, it says, rulings of courts of competent jurisdiction. So I'm not sure what they mean by competent. Like, are they questioning which court rules in favor of the housing provider and that's incompetent, or rules in favor of the renter and that is competent? So there's a lot of items in this area that are confusing, that are not clear. So I appreciate you taking the time to listen to this. Stay tuned for the next area. Talk to you soon.